before we resume this afternoon, could we mention that in relation to the programme for tomorrow,
yes,
the board thinks it would probably be more assisted by having a little bit more time to spend on the mortgage appeal rather than the immunity appeal.
Yes.
So we would like to request that we switch and do the mortgage appeal in the morning and the immunity appeal in the afternoon. It just gives us a little bit more time.
Thank you very much.
If you wouldn't mind discussing between you the distribution of time to allow for that, it may be the same, but if there's any
Yes,
change,
we'll
let us know.
discuss.
Thank you very much.
Thank you. Well, my lords, my lady, obviously part of this case is a question of statutory interpretation. And as ever, when one's interpreting a statute, one of course looks at the language that's used, but importantly, one also has to consider the context in which the statute was passed. And of course, it's common ground between the parties that this statute was one of a number passed to give effect to international legal obligations in the various conventions. But it's worth highlighting one thing, particularly in relation to the Palermo Convention, and I'll be able to go to it later if necessary. But articles in the Palermo Convention speak of a requested state giving the widest possible assistance within the constraints of its domestic legal system to the requesting state. And of course, the submission on behalf of the Attorney General is that what has been done here is within the constraints of Jersey's domestic legal system because it operates in personam on a person within Jersey's jurisdiction. So our submission will be far from breaching any principle of international law. This is doing what the actual convention requires, giving the widest possible assistance. Leading on from that, and secondly, of course, it's also worth considering the effect of what my learned friend's submissions would be. Take Baroque, one of the cases mentioned. There were companies in Panama, Costa Rica, the British Virgin Islands, and the United Kingdom, all controlled by a trust company in Jersey. But if my learned friend is right, and those companies received the proceeds of crime, taking Indonesia as an example, far from being able to go to one central point which controls all those companies, Indonesia would have to go to the expense of going to Costa Rica, Panama, the British Virgin Islands, and England. And that would be, in our submission, something that would slow the pace of international cooperation against the fight against crime. And it would lead to a perverse incentive for wrongdoers to set up more complex structures to put obstacles in the way of law enforcement. Now, of course, I have to accept that if a statute clearly is intended to have that effect, the court must give effect to it. But that rather startling result would tend to suggest that the contentions made by the appellant in this case are wrong, and that because of the operation of the Jersey statute, and in particular section 16(4)(b), that scenario can be avoided to a large extent. So policy behind the legislation is achieved through what's been written. That's our first point. The second point is that the drafting of the actual section of the SASE is clear. It distinguishes between, in section 4A, property held by the defendant himself in Jersey, and it's only that property that vests in the Viscount, as has been observed. 16.4b enlarges the position by creating an in personam jurisdiction over other persons. In this case, those other persons are the trustees. And there is, in our submission, nothing in the point that this is somehow confiscating property in another state. What has been required by an order under this section is that an individual within the jurisdiction and subject to it is the subject of a court order, to use a phrase, to repatriate funds or an item. Now, in the case of an industry like the trust industry in Jersey...
Sorry for interrupting, but if you repatriate funds, they immediately belong to the Viscount.
Yes.
Yeah.
Well, no, not necessarily. It depends if they're a gift. If they're the defendant's funds, of course, they vest under...
Yes, that's right. So you have property in a foreign country,
yes,
repatriated to Jersey,
yes,
and it is then becomes the property of
yes,
the Viscount. Isn't that an in
yes,
rem effect of the order?
Well, not necessarily, because the property that may be repatriated might be a gift to the specified person. It's his realisable property, not the realisable property of the defendant. But the indirect impact may be the same. I have to concede that.
Sorry, just on 4B, can that apply to the defendant? So
It says any specified person.
So if the defendant has property outside Jersey, you say an order could be made under 4B?
As long as the defendant's in the jurisdiction.
Yes.
And in fact, in the domestic jurisdiction, that can be done anyway.
Well, he's unlikely to be in the jurisdiction because he's likely to be in prison in the country where,
Yes,
which has made the confiscation.
yes. But here we're looking at the power in relation to someone who is within the jurisdiction, the trustee.
But it's because this is a tainted gift to the trustee.
That's exactly right.
So it's not the defendant's property.
It's not the defendant's property.
It would still be the specified person's, the recipient of the gift. So you say
Which is the trustee.
If it came back, it would still be their property. It wouldn't be.
Yes.
Court. But then how does it get to be used to satisfy whatever?
Well, it's unfortunately one of the provisions of the confiscation legislation, that although on the face of it, it's not the defendant's property, it becomes realisable property because a gift was made into the trust. There may be other property in the trust. It doesn't have to be tainted by criminality. That's the point, unfortunately, for those who are minded to try and evade confiscation by giving gifts to trusts and so on. It's still caught, although it's not in itself tainted property.
So how does it work thereafter then? Suppose, as you say, you can say to the trustees, we want you to transfer that money or those shares in wherever back to Jersey. So then they have those. You say they're not covered by 16.4a because they're not
the defendants.
The defendants. And then there has to be some further process in order
there will
to convert them into something that...
Yes, they have. They become realisable property, although they haven't come from the defendant, and they then have to go into the confiscated property fund after the registration process.
Registration of
the confiscation order in the foreign jurisdiction.
And how do you move from any specified person may be prohibited from dealing with any realisable property to the positive that any specified person may be required to bring the property back to Jersey?
Well, that seems to be one of the features of the jurisdiction. It exists in the domestic jurisdiction. No one seems to have, in this case, thought of the consequences. It says he can be prohibited from dealing with any property. Seems to me that in order to make this effective, and indeed one of the cases, it was conceded, I think it may have been Appellant, where the Viscount made the submission that someone could be ordered to bring property into the jurisdiction, and the court agreed.
It was Baroque, wasn't it?
But
it agreed in very short form.
it was Kaplan, I believe.
Oh, I see, right.
Yes.
Well, 2806 is also Baroque. So
Yes.
But
So it seems to be that certainly the Royal Court appears to have agreed that it had the power to order that.
how do you say it has the power?
Well,
as
I
a
think
result of that, of 16.
just give me one. Oh, yes, I'm just going. It's the wording at the bottom of 16.4, which goes on to say,
Any specified person, or
Yeah.
which part of it, in what way? And how do you...
the last
do it?
sentence, any specified person having possession of any realisable property may be required to give possession of it to the Viscount.
And what if it's incorporeal property?
Well, that's more difficult because, of course, all that the Viscount can get initially with this taking shares would be the share certificates. But that would give him control of the shares.
And the Viscount's duty to take possession, does that only apply to realisable property in Jersey?
Yes, it would have to be.
So the first part, the words "and the Viscount shall have the duty to take possession of,"
Yes. He has to get possession of it, obviously, in Jersey.
that only relates to property in Jersey.
No, it's property that may have come into Jersey, but the property does have to be in Jersey. How it got there could be one of a number of ways.
And would say, for instance, as in this case, there is land owned in a foreign country.
Yes.
Does the direction require the specified person to sell that property and to bring the proceeds of sale back
Yes.
to Jersey?
Yes.
And in effect, that is an order in rem against property,
Indirectly, it can be, yes.
against
It would
property in a
affect the
foreign
property,
country.
yes. I have to accept that. But the point I was going to make was supposing the person, the specified person, whoever it is, says, I'm not going to bring property back into the jurisdiction, then of course the only thing that could be done would be for the Viscount or anyone else in Jersey to go to that jurisdiction to take action in the courts. They couldn't seize the property under any authority from here if the named individual declines to cooperate.
Well, would there be proceedings you could take against the named individual? Would that be a
You can
contempt?
take contempt proceedings, of course. But I think as the courts know only too well, sometimes even contempt proceedings don't produce the desired result. I mean, the reality is, of course, with a trust company, because it's licensed, it would be unlikely to defy a court order, obviously. But,
Is there a power here, or has this been treated as including a power to order somebody to provide information about
Yes.
the property
Yes.
in the trust? Where do we find that?
well, I think it's always been done as part of the inherent jurisdiction attached to the power of the Royal Court. It can be done in a restraint order in England very frequently. It's done in cases of freezing orders where a defendant of freezing orders ordered to swear an affidavit is to render the order effective.
Yes, but it's done in England, ancillary to a cause of action
Yes.
in England.
Not necessarily. No, it can be done in conjunction with any freezing order.
And
Do I understand you correctly? You're basing your argument that there is a power to require a person to bring property back to Jersey purely upon Regulation 16?
Subject to... No, I think that must be right. I mean, in domestic proceedings, for instance, in England, in the case of Scarlett, restraint orders, which are broadly similar to this, to make the order effective, orders have been made to repatriate assets out of the jurisdiction back into the jurisdiction.
So just as the Viscount's duty to take possession relates to property in Jersey, then presumably the right to require a specified person to give possession to the Viscount, again, must be in Jersey.
Yes.
Yes.
So can you just explain the analogy with restraint orders a little further?
Well, restraint order operates not in an identical fashion, obviously, because no property vests under a restraint order in the UK. But it's an order restraining either the defendant or naming someone else from dealing with the property. Because confiscation order is value confiscation in the United Kingdom, what the court is looking at the end of the process is what the defendant's available amount or realisable amount is here. And in order to be able to meet that order in the course of the proceedings, as in DPP against Scarlett, which is in the bundles, you can order funds to be repatriated. And there's another example in here of a bank account in Dubai, I think it was, where a relevant gift had been made, I think it was to the sister of the accused, and the court ordered her to repatriate that money from Dubai back to the United Kingdom. So it's part of the process to make the court order effective.
And what was the name of that case?
Marchandine, which is... I'll just give you the reference in a moment. It's mentioned in our skeleton argument. It's 2966 onwards.
In DPP and Scarlett, that is the usual thing in a criminal trial of working out how much somebody's profited from a crime and then what how much available assets there are.
Yes.
And the profit is a worldwide basis, and the available assets are stretched all over the world.
Yes.
So you've decided on making an order, you've got to make it effective.
Yes.
Isn't this one slightly an anterior situation? And that is, can you make the order at all? That was an order made. The order that you repatriate was made to aid an order of the court.
Yes.
And so what's the order of the court here that's being...
Well, this is to aid, ultimately, the realisable assets being realised under this process to meet the external confiscation order.
But the specific order is the one prohibiting people, the specified person from dealing.
Yeah.
You don't need repatriation to make that effective, do you?
No, you don't.
I can certainly see that you need to have the power of the court to require the individual to disclose what property they have. But I'm struggling at the moment to see how it is that you need to repatriate in order to comply with 4B.
Well, see, with
The other way around,
yes.
as you say.
Sorry, you'll need to explain that to me.
No, I don't want to give your answer anyway. Whatever you think.
I'm inviting
So I say,
counsel to explain that.
on this case, the specified person, it's the trustees, obviously. It could also, I suppose, operate on someone who has notice of this out of the jurisdiction, like a bank and so forth. So the initial prohibition is from dealing with realisable property. But if one goes to the definition of what realisable property is, that is the property with which the court ultimately will be concerned.
Where do we see that?
Let's go into the definition.
Well, the definition includes property in Jersey or elsewhere.
Or elsewhere, yes.
Yes. So, I mean, you can prohibit people from dealing with property elsewhere as opposed to in Jersey.
Yes.
My question was how you construct out of that the positive obligation to bring the property back to Jersey.
But it seems in our submission that it must be an ancillary power to the making of the SASI. If you're required to disclose where your assets are, then obviously a further power could be under these provisions we would submit. Royal Court has the jurisdiction.
But it's strange that the words after the semicolon at the end of
Yes.
4 weren't made little d.
It is, I agree.
But you're treating them basically as if they were
Yes.
little d,
Yes,
a self-standing power rather than something that's related to the words in the full out
yes.
before the semicolon.
Now, of course, these particular provisions were the subject of examination by the Royal Court and indeed the Court of Appeal. And having regard to the purpose and context of the law, the general thrust of both decisions, which we would endorse, is that there is no objection to making a SASI over property which is held abroad as long as the person concerned is within the jurisdiction. And there's one matter I ought to correct in relation to the Court of Appeal judgment. My learned friend said that the Court of Appeal had relied on the administrative court decision of KBR, which was, of course, later reversed by the Supreme Court. But if one goes to paragraphs 66 and 67, which are on page 1589, 1590 of the bundle, in paragraph 67, the court said, although it recited KBR and what it thought the philosophy behind the case was, that there may have been a change in the presumption, they went on to say, however, that case had played no part in their decision.
They presumably knew it was under appeal at the time.
They did know it was under appeal, and they remarked that for that reason the respondents didn't rely on it.
Can you just help us with what happens with realisable property once it's been realised? How does the modified
the
law
system
work?
appears to work. You have to go through the registration process. So this is an interim step on the way to registration.
Right.
Once the external order is registered, and for that, as my learned friend said, the court has to be satisfied it's in the interests of justice to register the order.
So that's Article 39, I think we were
It
talking.
is, yes. Once that happens, there is then set up in Jersey something called the Confiscated Assets Fund. And the money has to be, the property is then realised by the Viscount, whether it's a car or whatever, and the money from the property then goes into the fund. Once it's in the fund, if you're dealing with an external jurisdiction, it then can be paid out in accordance with what's called an asset sharing agreement with the relevant jurisdiction.
And can you give us the provisions in the modified law that traces that process through?
I can. Yes, it's, if one looks, it's Article 20, which is on page 2123, which deals with the mechanics. So, first the sums come into the hands of the Viscount, that's Article 21. There's various deductions after payment of Viscount's fees and expenses be applied, it says, on the defendant's behalf towards the satisfaction of the external confiscation order, if you go down. The amount applied by the Viscount, this is Article 20, subsection 2, the amount applied by the Viscount towards the satisfaction of the external confiscation order shall be paid into the criminal offences confiscation fund. And then one goes down to Article 24, you find the provisions relating to the criminal offences confiscations fund.
Is that one big fund, or is there a separate fund for each confiscation order?
No, it's right, as I understand it, it's one central fund.
Under the ancillary power that you suggest exists to require people to perform positive acts,
Yeah.
does that extend to ordering a person in Jersey to convey a property in a foreign country to the Viscount, with vacant possession, for instance?
It depends, doesn't it? If the property is held by a company, which this is, it's of course the shares that go to the Viscount.
Yeah, but I was imagining a situation where a property was given by a criminal to his daughter.
Yes.
And it's in Singapore, and the defendant is in, and the daughter is in Jersey.
Yes.
So, can the court in Jersey order the daughter to convey the property to the Viscount with vacant possession?
If the daughter's within the jurisdiction, yes. But if the daughter were out of the jurisdiction, no. It'd have to go through the local court.
So the opening part of Article 20, so 21A, page 2123,
Yes.
that is contemplating both the money that's vested in the Viscount and money that's come into his possession pursuant to Article
Yes.
16 have to be
Yes,
paid
it is.
over. Why is there a difference between the two? Because I thought you said that if money is repatriated, does it then not automatically vest pursuant to Article 16(4)A?
64A refers to
Oh, I see. So the reference to has come into the Viscount's possession
Yes.
is looking at gifts to
Yes.
third parties.
Yes.
Right.
And then if you scroll down, you can see there's the provision about the asset sharing. and asset sharing is defined in 8.
Is it defined, what page, sorry? 8.
We're on 2125 and 2126, which
Where's the bit about asset sharing?
one just,
What's the definition on
Yeah.
2126?
yeah.
So I'm just trying to work out then if there's a dispute regarding the third-party property,
Yes,
which is said to have been a gift, has been taken into possession by the Viscount.
yes.
If there's a dispute as to whether it was a gift or whether the third party has some better claim to the money than
Yes.
the Viscount, does that get fought out at the registration stage under Article 39(1)(c)?
Well, it seems to be, it can be, as was in this case, there was the judgment about the gifts in this case was well before registration, so it can be dealt with before registration.
Right.
But plainly, the bailiff made the point that it would not be in the interests of justice, obviously, to confiscate someone's funds who had a genuine third-party claim on the property, and that was shown to be the case. So the third
Say
party,
interest of justice there, referring to the test for the registration of the order.
yes.
Yes, I was on page 2127 for Article 39.
And then if you look at it's Article 17 finally, which is after the order has been registered. You can see it's under paragraph 2, so the third person has to be given the third party a reasonable opportunity to make representations. And that can occur in fact after registration if it emerges later.
Yeah, Article 17(1).
Yes. Says
Why is that not the power for the court to give power to the Viscount to, if you like, get in?
but it
foreign
is as
property?
well, yes. Yes.
But, you know, I mean, you say as well.
Well, sorry, I anticipated the issue as to whether there's been a gift which is taken into account can be litigated at an earlier stage than registration. I was anticipating a question your lordship didn't ask.
Because 17 is only once registration has happened.
Exactly.
So I'm just trying to see how the scheme works.
Yeah.
And it might be said that Article 16 enables you to go at an interim stage before
Yes.
registration
That's right.
and just freeze things
Yes, that is.
on an in personam basis.
Yes.
Then you move on to registration, and there's
Yes.
been argument about third-party rights, maybe
Yes.
at the interim stage or at the registration stage.
Yes.
But once you've got to registration, Article 17(1) seems to give the court power
It
to
does.
authorise the Viscount to realise in such manner as the court may direct any realisable property.
Yeah.
And so that language would seem to might be said to cover repatriating
Yes.
the property at that stage.
Yes.
That's realisation.
Well, I'm not
It's
sure.
got to have
because
come into
that's-
his possession
yeah,
pursuant to Article
yeah,
16.
Possession already.
Right.
It has to be vested in the Viscount.
Or in his
Viscount,
Or in his possession.
yeah.
Yes, I see. Okay, so you need to get in order for Article 17(1) to apply, it needs to be in the Viscount's possession.
Yes.
So what actually happened in this case? How was the value of the Singapore property realised?
It was sold, but there were...
But sold by the trustee? Well, the trustee took the shares, did it, of the company that owned the property?
No, it was the bank.
Oh, sorry, the Viscount took the shares.
But
Took the shares and then used
reason it was
those.
sold was there's a mortgage over the property, which the bank realised they got authority for power of sale,
I see.
and then the property was sold, and the proceeds came to the court ordered the proceeds to come.
So who did the court order to bring the proceeds of the sale into the jurisdiction?
The Viscount.
Yes, I know, but how did the Viscount get hold of the...
Well, because the bank, by consent, remitted the sale proceeds after the property in Singapore had been sold.
The proceeds of sale are in Jersey.
Yes, they are.
But I understood that there was some without prejudice or without admission.
Yes, we were not going to submit because, as it happened, the proceeds of sale ended up in Jersey. Therefore, it was property in Jersey. Therefore, there was no jurisdiction argument. That was the why. It was to preserve the position pending this appeal.
I'm still not quite clear. So the bank exercises its power of sale, so then it can take from the proceeds of sale what it needs to pay off
Yes.
debt owed to it, and I think there were £2.5 million left.
Yes.
So how did that money, which ordinarily would be payable to the trustees,
Yes, it was dealt with by consent after the bank had deducted their share. It was then brought to Jersey.
But consent between whom?
Yeah.
Between
I
whom?
think the trustees, we can check, there is an order somewhere, consent order covering it, but it was dealt with by consent anyway.
But in principle, the money is payable to the company which owned the property
Yes.
in Singapore.
Yes?
The shares of that company are held by the trustee, are they? But the
Yes.
trustee hands over the shares to the Viscount. Is that how it operated?
No, because...
The trustee just exercises its power as a shareholder.
Yes. Yeah. That's... I'm just having Mr. Marnie's just...
I thought I might have read somewhere there was a receiver appointed, but that may be wrong. Yeah, I imagine that.
I'm sorry for being not following exactly. Why haven't the shares been handed over to the Viscount?
Well, because they're not held by the... Well, I don't know is the answer.
Yeah.
They are in Jersey. They're in the offices of the trust company.
Yeah.
is that, well, there's a dispute
No,
over the
dispute about
citus.
that.
I suppose we may go to the citus, yes. But, we'll turn up where the consent order was that the money came back into the jurisdiction.
Right, but it would be useful to have some sense of what would actually happen if people weren't quite so cooperative. How would the proceeds of sale in the hands of the bank, once it's exercised its right to sell?
If they were not cooperative, the reality is you'd have to go to the jurisdiction and say there was a court order from the Royal Court in Jersey. You'd have to get the other jurisdiction to recognise that order in accordance with their laws. Ultimately, it's the court's exercising an in personam jurisdiction. It can't go further than that.
So you would have to say to the Jersey trustees, you must, in your capacity as shareholder, cause the company which holds the shares,
Which is within the trust.
which is within the trust, to make the company declare a dividend or whatever, or somehow hand up the money to the trustee, and then it would come with it
Yes.
into the jurisdiction.
Yeah. And we deal with this point it's paragraph 48 of our skeleton argument, where we point out that you can't bind people who are actually outside of the jurisdiction of the court unless a local order is made, if there's no cooperation. As I said, the reality is with a trustee, you will get the cooperation. May I move on, briefly deal with the three cases relied on by my learned friend, which were King, Perry, KBR, and the Guernsey equivalent of King and HM Procureur.
Yes.
First of all, King and the Serious Fraud Office, which was the first of them. One has to be careful, because although my learned friend submitted that the legislation was very similar, it's not in fact that similar, because as Lord Phillips made clear, the aid to interpretation in that case was the fact that the necessary legislation, as he put it, from first to last, mentioned England and Wales. So although there was a wide definition of property in the main act, the actual order under which the external confiscation orders were enforced specifically mentioned property in England and Wales. As a result of that, that qualified, Lord Phillips said, the wide definition in the Proceeds of Crime Act. Here,
So show us, where do we see that in the judgment?
if one goes, first of all, the report starts at 2815.
Yeah.
It's paragraphs 31 through to 34.
2822.
Yes.
$32 doesn't seem to be dealing. 31 and 32 are dealing with points on the fit with the conventions, I think, aren't they?
If I just go up, in fact, it's 34, paragraphs 34 and 35, it's a bit further down, where it says, it's under the heading, the natural meaning of the order. And he quotes from the statute, he just says, jurisdiction to make an external restraint order only arises where the external request, quotes, concerns relevant property in England or Wales. And that's as a result of Article 6.
Yes, thank
So
you.
what they're saying is that although POCA
Yeah,
itself
wide general
applied very widely, the equivalent of the modified law
Yes,
for external confiscation orders was much more limited.
that's right, limited to England and Wales, and that was the decisive feature in the case, which is, of course, not the case here. Our submission is that the definition in Article 1 is carried through into the 2008 regulations and isn't amended in the order. So there is a major difference in the drafting of the relevant legislation that they were looking at.
And was Mr. King within the jurisdiction of the English courts?
I don't think he was. He had been some years ago, but I think he was now in South Africa.
Well, it's in paragraph 1, he's on occasion to travel to outside South Africa. Right, so he's in South Africa.
He's in South Africa.
Right, okay.
I think Article 7 and paragraph 18
Yes.
is important, isn't it, on 2820?
Yes.
So the request had to identify relevant property in England and Wales to which it related.
So that seems to be a scheme based not on jurisdiction in personam
No,
at
it's
all.
not.
It's based on
Property in,
jurisdiction arising from the property actually being in
Yes.
England and Wales.
yes. That's the distinction. So we're not looking at the same, as I say, statutory scheme.
Yes.
Soccer and Perry, which was the next authority, which starts at page 3156. Again, it's looking at a different scheme to the Jersey scheme. It's actually looking at a civil asset recovery scheme. Very relevantly, Part 5 of the Proceeds of Crime Act of 2002, the issue actually for the Supreme Court was whether the Act permitted what were in rem proceedings to be brought directly against property outside the jurisdiction. In fact, the submissions in that case, according to Lord Phillips, he accepted, of course, that there were a number of relevant considerations in that legislation, but he did point out that those provisions of international law about not making in rem orders against property in another country had to be read in the light of various international conventions, and that had been modified. And in fact, he also remarked.
Sorry, where do we see him making the point you just
Yes,
mentioned?
I'm just getting his. It's in his summary, which was at the very start of the judgment.
3167.
Yes. It's a very long judgment. Right at the very start, he sets out his.
If you go to 3169, paragraph 17, you have a quotation from Lord Diplock. Under English rules or contract laws, is my view well established in English courts no jurisdiction, either in criminal or civil matters, to make orders purporting ipso juro to transfer movable property situated abroad. The example I gave was exactly that.
Yes.
Okay? And the qualification by Lord Phillips was, well, you've got to now look at that in the context of international law.
Yes.
But there's no international law requiring that.
No.
Where's the... you can certainly see international law now moving to a situation where it's made easier to confiscate property inside the jurisdiction. But where's the international law that says that you can make orders purporting to transfer movable property situated abroad.
No, well, that was the point. Lord Phillips said there was no such jurisdiction, and that's why the very ambitious submission made on behalf of the Serious and Organised Crime Agency failed, because it would affront international law.
And if you look at 3166, paragraph 9, about halfway through, between F and G, Mr. Jones submitted that such an order took effect in rem. He submitted that it would be a breach of international law for English courts to make an order in rem in respect of property in a foreign jurisdiction, and also if that property was real property. And, but the effect of the order that the effect, I think you've accepted the effect is that an order for in rem would be made.
Well, indirectly, if the various things happen, but the point is ultimately, if someone chose not to obey that order, there could be no question of any in rem proceeding. Although, as I say, I have to accept that an order in persona may have an effect on property outside the jurisdiction.
Yeah.
So I think you were going to take us to another part of Lord Phillips' judgment.
Oh yes, I apologise. It's slightly above there. It's one of the. I'll just go to it. It's paragraph 15. To do with the presumption my learned friend has relied on, which he mentions there, that the presumption is that Justice Meeting started with, and then it goes through, but if one goes higher up, which is where I was going to go, having mentioned that. It's little 2 on, actually on page 3167. These are the summary conclusions of Lord Phillips, where he remarks the defendants have placed undue weight on the presumption that a statute does not have extraterritorial effect. So although that played some part in the reasoning, it wasn't the main reason as to why the application by Soccer failed. So finally, in the trio of cases, we come to KBR, which I can take very briefly, because it was dealing with a rather different situation we would submit. But its importance lies in the fact that it did look at this presumption against extraterritoriality and whether it should be given effect. It's at 3089. Lord Lloyd Jones said the answer, as he put it, as to whether Parliament intended to confer the extraterritorial power will depend on the wording.
So which paragraph are you?
27, I apologise.
Thank you.
And he pointed out that this will depend on the wording, purpose and context of the legislation, considered in the light of relevant principles of interpretation, principles of international law and comity. Now, our submission here is that if one applies those principles here, if you look at the mischief aimed by this legislation, the particular context of Jersey, which the Commissioner Mr. Clyde Smith in the Royal Court judgment mentioned, namely the trust industry in Jersey, the way companies are structured, and the fact that set laws and the property are very frequently abroad, the modified law makes sense. And because it operates in personam, our submission is there is no breach of international law or comity.
It said against you that there are no other jurisdictions which give effect to external confiscation orders in this way. Can you give us some examples of any that do?
None that I'm aware of. But, no, we don't know. We haven't done a survey of other jurisdictions to see how their laws operate. But it's perhaps because of the peculiar background of Jersey in the sense that its main industry is the trust industry that this legislation is structured in this way, rather as Clyde Smith said so in his judgment.
Just wondering, on a practical level, what's the problem? You have trustees in Jersey.
Yes.
And you can order them as specified people.
Yes.
Not to do things.
Yes.
Okay. And and for instance, the bank could never get a discharge for its money in this case unless it actually paid the money to the trustees in Germany, in Jersey. They have to. The bank owe the money to the company.
The balance, sorry.
Yes, the bank owe the money to the company.
Yes.
And in effect, you can order the company or the trustees or whatever you like in Jersey.
Yes.
And not to deal with that property.
Yes.
And so isn't there sufficient protection by prohibition rather than having to repatriate?
Well, there could be, but as I say, if someone outside being a trustee, a specified person who wasn't a trustee, then it may be that you would have to order repatriation.
Well, it only gets into the fund, which is where it needs to be, once it's in the possession of the
Viscount.
Viscount.
And the specified person has a duty to give possession to the Viscount.
Yeah, but I don't think that the Viscount can be in possession of money which is not in Jersey, can he? Or?
Well, it depends how one defines possession. If it's control,
it's going to be quite, yes. But if the bank in Indonesia held on to the excess of the proceeds of sale, well, we were just exploring this before. What is the chain that gets that money held by the bank after it's sold the property into the hands of into the possession of the Viscount and thence into the...
I mean, in this case, it's obviously done through the medium of the trustees, but... And finally, just to revert to KBR, of course, we question whether there's an exact parallel with this case, because specifically mentioned in argument was the issue of, well, faced with a notice from the Serious Fraud Office, what if an English company had the information abroad and therefore was within the jurisdiction? And the court said they doubted very much in those circumstances whether there was any extraterritoriality involved, because the person was within the jurisdiction. And that's the situation which was...
Where's that?
It is, if we go to the 30...
Paragraph 30, I think, 3090.
Yes.
And G.
Yes, it's starts at paragraph 30. And then if you go right down to the, he says, however, this is in paragraph 30 on page 3090. First, it is questionable whether in the hypothetical situation, that's where the company is in the UK but the information is abroad, whether in the hypothetical situation the legislation has given any material extraterritorial effect. A UK company would be required to produce here a document it holds overseas. It would simply be required to bring that document into the jurisdiction in order to produce it. Secondly, as we've seen, the presumption against the extraterritorial effect, if it applies at all, applies with much less force to legislation governing the conduct abroad of a UK company, as postulated in the hypothetical example. Thirdly, in any event, this casts no light on the intention of Parliament as to whether the provision should apply in the very different circumstances of the present case. So those are the passages we rely on in KBR.
So you say that money is like a document?
Yes. Fourth case, King against HM Procurer. This is paragraph 87 of our skeleton. Just to cross-reference where we deal with this. Now, of course, I have to concede that on the face of it, that case of King, is against the proposition I've put to you. But of course, it was considered both by the Court of Appeal and the Royal Court in the instant case. And if we go, first of all, to the Royal Court judgment, which is at 1459, and the relevant passage, which is paragraph 58 of the Commissioner's decision. And there seems to be 2 points arising from this. One is that, of course, the judge in HM Procurer and King's not referred to the earlier Jersey cases, which had taken a different view of the of similar legislation. And then,
well, are you able to help us with what the Guernsey legislation was? The question asked of
yes,
your opponent, which he couldn't help us with, so maybe you can, since you had advance warning.
I apologise, I didn't actually check if I...
Is it set out anywhere in King and HM Procurer?
Just checking if we've got it in the bundle. Is it 5003?
Sorry, is this the King Procurer case?
Yeah, it's the Guernsey. I was asked about
2826 is the...
But you're taking us to the legislation itself,
Yes.
are you? The Guernsey legislation?
Yes. 5003. Yes. 4696, I'm told. Apologise.
696.
Oh, I see. So the 5003 is the principal law, but the ordinance is 4696.
What do you want?
Which is a relevant
I'm
part
just
of that?
trying to find the relevant section.
Or that you might be expected to know if you're going to be distinguishing the case, or saying it's wrongly decided, or whatever your submission is.
Saying it took a different view. Yes, I accept that.
It may be very material if it's identical legislation, they took a different view. Or...
I don't know how consistent we think that the equivalent provision
is section 26. But it operates rather differently. The whole scheme for enforcement is...
Sorry, can you assist us with the page number?
Oh, I am sorry.
754.
Thank you, yes. 4754 is suggested that.
It begins at 5003.
Thank you. I think we've got the page for section 26.
Well,
Where's the ordinance? I'm just finding the volume.
the restraint orders under the actual law are...
It's 4754. Yes, that's it. Under restraint orders? Yes. Yes.
That's it.
So subsection 4 seems to include power to appoint a sheriff as receiver.
Yes.
Right. So what do you say we take from this?
Well, it's not identical legislation. Our submission simply is that, first of all, the Procurator based it on the definition of property. He said that the wider definition of property, Guernsey or elsewhere, didn't apply in this context.
Sorry, who said?
The judge in Guernsey?
Judge.
Right, can you show us where he said that?
Oh, I've paragraph 12, paragraph 12, judge.
Right, okay. 2838, I think is...
Yeah. The other feature of his judgment I was going to point out was that he also seems to have been influenced by the terms of the letter of request. Because if we look at paragraph 12, he says just up above, he mentions the extended definition of property in section 50 of the 1999 law, and the presence of the Guernsey trustee, which controls the property outside Guernsey, is amenable to an order of the Royal Court, and then says, in the letter of request, the South African authorities sought the grant of a restraint order only in respect of Mr. King's property in Guernsey, including any interest he has as a beneficiary of the trust property. And then he just said the scheme for restraint or charging orders in Part 1 of the 1999 law, as modified, is directed only to property in Guernsey and enforcement in respect of such property. The wording of the sections in Part 1, as cited above, on its natural meaning does not apply to property outside this jurisdiction. Definition in section 50, which is the wide definition, does not override that natural meaning. It does not apply in the context of Part 1. That seems to be the core of the reasoning. Now, first of all, the scheme isn't identical, but secondly, in our respectful submission, the points made by the learned commissioner in this case are, first of all, that he doesn't explain in terms why he took that view, that the property definition didn't apply, where it's mentioned in the order. Secondly, that the earlier decisions in the court in Jersey were not drawn to his attention. And thirdly, the Commissioner, looking at it again, of course, Guernsey authorities are only persuasive in Jersey, was not persuaded by it, nor was the Court of Appeal. And then, of course,
It seems to me that if we look at 5017, that is the modifications that were made to the Guernsey general proceeds of crime law. This was the modifications of that law as it applies when you're dealing with an external confiscation order.
Yeah.
But what I can't see, then it substitutes a new definition for realisable property. That doesn't seem to limit it to property within Guernsey, unless I'm missing something.
Well, that's...
That seems to be so from the judgment, doesn't
Yes.
it? Because the Guernsey judge is saying, despite what the definition
Yes.
says, I'm going to treat the word as meaning what I think it
Yes.
otherwise means.
Well, that's our submission, but that's the view that the Royal Court and the Court of Appeal took.
I mean, just on what the Guernsey law provided for at section 26.4, page 4754 to 5.
Yeah.
I mean, that does seem to contemplate, doesn't it, albeit through a process of receivership, that property which is located abroad may, through a process of management, be brought
Yes.
within Guernsey
Yes,
and
it does.
taken into control
Yes.
in Guernsey.
Yes.
Yes, but section 24 doesn't apply when you're using the law for a external confiscation order.
Sorry, section 26.
Oh, sorry.
Section 26 is the restraint order.
Yes.
At first blush, we'll need to take a bit of time to digest this.
Yes.
Section 26 looks as though it's set up on the basis you restrain,
Yes.
and then section 26.4, there may be a process, having restrained, of bringing within the jurisdiction that it can
Yes.
be used,
Yes.
the property can be used in a particular way.
Yes.
Because you were asked before, I think, whether there was any other jurisdiction that had
Apologise, I hadn't
gone wider. And
Yes.
but tell me if I've misunderstood. It seems that this has gone wider, as in line with your submissions about Jersey. Is that right?
That's right. Yes.
And he's appointed, page 455, letter B, directions to manage or otherwise deal with any property in respect of which he's appointed. He's appointed to deal with what property?
I'm so sorry, I missed the reference.
Well, at 4755, he's in accordance with the court's directions to manage or otherwise deal with any property in respect of which he is appointed
As a receiver.
As a receiver.
as a receiver. Yeah. And can he be appointed as a receiver in respect of property in another country?
Let's go back to the judgment. see nothing in the judgment which deals with this particular issue.
Well, it's evident from the judgment. The judge took the view can't be because he thought property only means property should be construed as meaning property in Guernsey.
Yes, there's nothing else in the way he deals with this. He mentions the powers in passing, but he doesn't go into them in detail. No.
But there isn't a handy consolidation.
No, there isn't, unfortunately, in the case of the Guernsey laws.
So where do you want to go from here?
I was going to, dealt with care, I was nearly going to mark, our submission is that, first of all, the legislation is slightly different, but there seems to be no reason why the wider definition of property in that case couldn't have applied, and we would urge the board to follow the decision of the Royal Court and Court of Appeal. In answer to an earlier query about how the proceeds of sale came to Jersey, I'm told if one goes to page 104, that seems to be where
What are we looking at there?
earlier judgment of the Royal Court as to how the property came. It's
Where do you want us to look
paragraph
at?
10, sorry. This is how it originated. So this arose in connection with the bank's application to exercise a power of sale.
Oh, I see. So you're saying it was made a condition of them exercising the power of sale that they remit the balance to the Viscount. I see.
Yes.
So that judgment seems to be predicated on the idea that the order does have the effect
Yes.
of binding in some way in respect of the property in Singapore. So the bank thinks that it has to come forward and
Yes.
get released. But am I right? If the the appellant's appeal in this appeal is correct, then that was an incorrect assumption.
Yes, their case in that appeal is no consent is required.
Yes.
Yes. In fact, the order which the actual court made starts on page 98, I think it is, yes. And goes, checking him out.
Right, so where do you want to go next with your submissions?
So far as we're concerned, the only final thing we can go to is the issue of, which was raised, of other jurisdictions. Our submission would be, although of course what's done in other jurisdictions may be interesting, ultimately one is having to construe this statute in accordance with principles of interpretation that apply in both England and Jersey. And whilst it may be interesting, they're not aids really to the interpretation of the legislation, particularly where it's been conceded that there is actually no breach of any international law obligation, and making an in personam order in Jersey which has effect outside Jersey.
And I think you said you were going to show us the Palermo Convention that no one has yet.
Oh, yes. Now, give me a moment. Turns up.
And can I check, do you confirm that this is the relevant convention insofar as any convention is relevant for us to look at? Or
It's the one that was invoked by the government of Indonesia in the letter of request. That said, it hadn't actually been extended to Jersey at the time of the letter of request. It was subsequently.
Right. So you better give us that time frame. So letter of request dated.
First one, let's just go back to the record. Just give me a second. It's in the chronology, actually.
Chronology page.
It starts on 1639. Yeah, it's 2009 was the first letter of request. And then in 2013, there was a second letter of request, July 2013. And the first says he was not made till August of 2013.
It was August 2013, wasn't it?
Yes.
And what was the state of international obligations in respect of the UK in respect
I
to
think
Jersey?
whatever the position in England was, it had to be specifically extended to Jersey, and it wasn't at the date of the first letter of request.
Right, but you told us there was a second letter of request. Has it
July
been by then?
2013. I think we've got the date somewhere that the,
Yes, that's what we're asking for.
yes, it's in Klein-Smith's judgment in Dorsdale, I think. I'll find it in a minute, but the actual articles of Palermo, it's 3328.
But, sorry, just before we get to Palermo, did it apply at all in respect of the relevant letter of request?
I don't think it did. Yeah.
The operation of the scheme under the modified law, can any country make
Yes.
a request regardless of whether there's a treaty
Yes,
to which they and Jersey are both parties?
Yes, because previously it had to come from a designated territory.
Right.
And that was the problem. Jersey didn't keep up an up-to-date list of designated territories.
Right.
So in 2008 it was altered so that any country could apply under the 2008
I think I read somewhere that the SACI were made under ordinary comity.
Jersey, although the Palermo Convention was not brought into force, it regarded itself that it should follow the convention.
Okay.
I was just going to go to, it's 3328, it's the convention itself is set out.
And I think, at an earlier point in your submissions, you said that what was sought to be done in this case was in compliance with
Yes.
Jersey's obligations under.
It was Article 12 I was referring to.
Which is at page.
I don't seem to have one. Yes, I think it might be Article 13 on 3339.
It's just,
Article 12's been cut out.
oh, so it has. The actual text referred to on page 35, or the start of the text of our skeleton argument. But, yes.
Well, let's identify which provision is relevant first. Is it Article 12? Even though
It was Article 12 I was quoting from, about states parties shall adopt to the greatest extent possible within their domestic legal systems such measures as may be necessary to enable confiscation of a series of matters, but one of which was the proceeds of crime derived from offences covered by this convention or property, the value of which corresponds to that of such proceeds. And that's the widest.
I'm so sorry, you set that out in which paragraph of your written case?
98.
98. Well, I think just for...
Article 13 also covers.
We'd better ask to have the full text of
Yes.
Palermo if that's
Yes, we'll ensure
being relied
that.
on in due course. But
And the date on which it applied to Jersey.
17th of December 2014 is when it was applied to Jersey. 17th of December 2014. So just after the second letter of request. But Article 13 on page 3339 makes the same statement about in relation to confiscation. It says a state party that has received a request from another state party having jurisdiction over an offence covered by this convention for confiscation of proceeds of crime, property, equipment, or other instrumentalities referred to in Article 12, paragraph 1 of this convention, situated in its territory, shall to the greatest extent possible within its domestic legal system. Then it sets out a series of obligations. But it's the point is within its domestic legal system. That's the point I was making. And then there's obligations to submit to competent authorities and so on.
The appellant presumably emphasises the word situated in its territory.
Yes, that's, yes. Now, so far as...
sorry, just on that, I mean, this seems to be an obligation directed solely to realisation of property situated within its territory. So
Yes.
I'm not quite sure that I follow why you refer to this.
only for the statement of the philosophy behind these conventions, that states are under an obligation or should provide assistance to the greatest possible degree within their own domestic legal system.
But
Or
only,
assistance for something else. Then.
yeah, it's only to realising property
Yes.
within.
But so far as that's concerned, obviously there's nothing in the conventions which prohibits us, or Jersey, from making an in personam order within its own jurisdiction, its own territory, which may have an impact outside.
Yes, so where do you want to go now?
Well, subject to those points, those are our 4 submissions. The law's clear, the context matches the law, and there's nothing remarkable about the exercise of this jurisdiction. It's equivalent in many ways to a civil freezing order jurisdiction, and in any event, as a matter of fact, at the time this legislation was passed, the Royal Court, in any event, and other civil jurisdictions had jurisdiction over trustees who held property abroad. So there's no exorbitant jurisdiction point we would submit.
Yes, thank you very much.
Yeah.
Now, Mr. Thompson, I think you've used up strictly your time, but I'll give you 5 minutes if there was anything you particularly wanted to say.
I would, if I may.
Reply.
Could I? It's very important I come back on the thing which Mr. Thompson was just talking about. Whilst it is true that no of the conventions say you may not do more than is in the conventions, of course none of the conventions say that you may do more. What we need to look at is what the conventions actually sanction. And what the conventions sanction is action in the territory of the requested state against property in the territory of the requested state. And that is what Jersey is undertaking to do through the modified law, and we see that defined in Article 13 of Palermo. Could I just, as a miscellany of points that I will deal with as quickly as I possibly can. A friend relies on the obligations under the conventions to use the widest possible measures and so on. Well, that point was argued in paragraph 28 in King. That's page 2821. It was one of the points that the prosecution relied upon, but it did not affect the result in King because of the scheme identified and the width of the scheme identified by Lord Phillips in his speech. Another very important point, repatriation orders in respect of property, and it's quite correct what my friend says about in domestic cases, Merchandani being one, Scarlet being another. In those cases, repatriation can be ordered, but as Lord Phillips explained in Perry at paragraphs 31 to 37, those cases, he didn't mention them by name, he talked about domestic order cases, those cases are a totally different category. They have nothing to do with international confiscation, and they depend upon the in personam jurisdiction over the defendant who is convicted before the court. The whole analysis is set out in paragraphs 31 to 37.
Yes.
My friend seeks to suggest that the court could craft on to the implied law a further power over and above those powers which are identified, requiring property to be brought back to the country. But this is what that would amount to is effectively re-legislating the content of the modified law. It's simply impermissible. This is a penal statute. And it is not appropriate for action of that kind, which is not expressly contemplated by the modified law, to be crafted on when there is no basis for such wording in the statute itself.
Yes.
Could I say something about KBR very quickly? It is right that the Court of Appeal said in paragraph 67 that it was not relying on KBR, but in paragraph 66 it used KBR to detect a policy change since King. And so whether or not it expressly was relying upon KBR in reaching its conclusion, the detection of a policy change was without, as we now know, proper foundation. A very small point of detail here. The money, as it was remitted from Singapore to Jersey, that was subject to an order, which you'll find at page 261 in the supplemental bundle. The purpose of that order...
Is that the supplemental record?
The supplemental record, yes.
Yes.
If you go to page 247 in the same supplemental record, you will see an exchange between the Commissioner and the counsel for the Crown, Mr. Belham,
where it was Mr. Bellum, for the attorney, who said the money will be held inviolate. And the commissioner said, well, yes, that makes absolutely good sense. And that was at page 247. So it was not intended that the remission of the money to the Viscount should in any way enable the Jersey authorities to say, we have the money. It was simply to secure the money. So if the money was due to Jean Zell before it was remitted, it's due to Jean Zell now. My friend...
I see, so it wouldn't then be in the possession of the Viscount for the purposes of Article 16.
It would not. One can't get a stronger word than inviolate, and that, in fairness to the Attorney General, that was the wording of his counsel in the Royal Court.
Is that where things stand at the moment? Has that changed?
No, it hasn't, not at all. You'll find it at page... The actual wording used at the time, 247, that order has not been modified.
No, I meant, has the situation with the money changed since it was repatriated on that basis?
The Viscount sits on it all. It's
right.
£250,000.
And you would say, I suppose, that if it's the case that it's not, that the court does not have jurisdiction to order the repatriation of the money, then it would be also outside the jurisdiction of the court to insist on that as a condition of granting the permission to sell, assuming that permission to sell requires permission.
We would submit that. The only person who can give a receipt for that money is the company to which it's entitled to it, namely Jean Zell.
So is this right, that the balance of the proceeds of sale are in effect sitting in an escrow account, which happens to be under the control of the Viscount, but the Viscount is not pending a resolution of these proceedings, treating it as property vested in him in any way.
My Lord, I agree with that formulation. What it really comes down to is this, that the money is, as it were, before it was remitted to Jersey in the first place. In other words, it's money outside the jurisdiction.
Right.
So that's why we say, if the appeal succeeds, the money has to be released to Jean Zell.
Right.
Because Jean Zell is the only person who can give a proper receipt.
And and released where? Would it be paid to John Zell in
the BVI?
In the BVI. Oh, I see.
Well, it's the position is, of course, I mean, this will come up in the mortgage appeal tomorrow. The law of Singapore is exactly the same as Section 105 of the Law of Property Act 1925. Once the property is being sold, the mortgagee has to pay the money to the person who is entitled to the net proceeds of sale. And that is, under Section 105 of our legislation, under the Singapore Act of 1886, it is the mortgagor. Right. The mortgagor is Jean Zell.
Yes.
So the person who controls the mortgagor are the trustees?
They are.
Yeah.
They are indeed. Yes.
And so they are effectively the people giving the receipt?
They are the people giving the receipt.
And they're in Jersey?
They will be giving, with respect, my Lord, no, because the receipt would come from a BVI company, not a company in Jersey. Jean Zell is a BVI company. It's owned. The shareholding may be owned by people in Jersey, but it's a BVI company.
But the trustees can direct the company not to give a receipt.
Or to require the money to be paid into a bank account in Jersey, let's say.
Yeah. They could do that. Of course, the question that this board is concerned with is whether they should be so ordered. And we say, for the reasons we've submitted.
Well, they can certainly, subject to any other views, be prohibited from doing anything that would imperil their realisable property. I mean, this is realisable property.
Well,
they could be prohibited from.
My Lord, that all comes back to the question. I'm sorry to go back to this. It goes back to the question: should a saisie have been granted in the first place? If the
operation of the modified law is, as we submit it, is per King, Perry, and King Guernsey. If that is the operation of the modified law, this says he should never have been granted in the first place. So it shouldn't be so interpreted as to require the trustees or the directors to behave in the manner sought by the Attorney General.
Yes.
One other point. The position with regard to a receiver, even if a receiver were appointed, the power of the receiver does not extend outside Jersey, we submit, and our authority for that is Perry at paragraph 35, where the authority specifically says that the receiver would not have powers outside the United Kingdom.
Page number, please.
Apologies.
Right, if you haven't got it, don't worry, we will find it.
Well, yeah, it's paragraph 35. But he goes on, and this takes me back to where I was this morning. He goes on to make a point which seems to have been very important to him, because he not only mentioned it in King, but he elaborated upon it in Perry. Section 74, the power of a UK authority to go abroad to recover money. And he says the receiver has no power outside the UK. For that, for looking outside the UK, you must look to Section 74. And then he says, but in the case of external orders, there is no equivalent of Section 74 for going outside the UK. And we say, snap, that is the position here. There is no provision enabling anybody in Jersey to go outside of Jersey to seek enforcement.
Yep. Thank you very much.
Thank you, my lord. Sorry, I'm still being fed instructions.
All right, take a moment just to make sure that you've said what you need to say.
Thank you very much. Yes, it's the same point is covered. Mr. Smith is anxious that I make, and he's quite right to do so. The same point is made in paragraph 910 in King Guernsey, and you'll find that at page 2835.
Yes, thank you very much.
I'm very grateful for the additional time.
Not at all. Well, we're only part way through the menu of appeals. We're very grateful for the submissions we've heard in this appeal. It seems sensible that we break now and resume tomorrow morning with, as we've requested, the mortgage appeal first, to be followed by the indemnity cost appeal. Very well. We'll rise now. Thank you.